So the first thing I want to talk to you all about, surprise, surprise, has to do with H-1B cap season. We are in the throes of preparing and filing H-1B petitions. And I've been getting questions lately around travel. And so if you are here in the US and you are perhaps an F1 student, currently an OPT, and you are thinking about traveling home, please, 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 before you buy plane tickets, before you make plans with family and friends, please have a conversation with your company, your manager, so that they or you can also have a conversation with your immigration attorney. Under certain circumstances, leaving the country and then trying to come back in will trigger the $100,000 fee. So we want to make decisions, but we want to make informed decisions around travel, especially with new H-1B petitions. So please make sure that you're reaching out to counsel before you make any concrete travel plans. Next thing I want to talk about is enhanced vetting security. We are seeing biometrics being rerun. So that means fingerprints, photographs on a lot of pending cases that generally require biometrics, where frankly biometrics may have already been taken. So we're seeing those be rerun. So what that means, it means a couple things. One, sort of the rubber hits the road. It probably means that processing is going to slow down a teeny bit while they rerun biometrics and then reanalyze the results of those biometrics. So, plan that into your processing timelines. Plan it to take a little bit longer if your case type requires biometrics. So green card applications, adjustment of status applications, asylum applications. So just, keep that in mind, that we're looking at more biometrics. So don't be caught off guard if you get an RFE for only biometrics. When you change your residence and when you're in the United States and you change your residence and you have some sort of immigration status, so whether you're a non-immigrant, whether you are a non-immigrant trying to, whether you're sort of then processing a green card, whether your green card is pending, whether your non-immigrant application is pending, whether your citizenship application is pending, or whether your green card application is approved, but maybe you haven't even started your citizenship application. If you change your residence, you must let USCIS know. The form that is used to alert them to that, to notify them of that, is called the AR11, so Alpha Romeo 11. And you can fill that form out on paper and mail it in. You can pull it off of the USCIS website, or you can do it online. If you do it online, you can just go to the USCIS website and do it, or if you have a My USCIS account, you can change your address through there. Why am I mentioning this? I'm mentioning this because USCIS wants to change the data that it collects on the AR11. And some of the new data that they are requesting really doesn't have anything to do with an address change, which again is the purpose, has always been the purpose of the form. So it appears that they are changing the fundamental purpose of the form, but they are now wanting to collect, in addition to your new address, your employment, your education, your current education, your current employment, and receipt of any means tested benefits. So the receiving of means tested benefits looks at whether or not you're a public charge, whether or not you can fully support yourself while you're in the US, specifically when you're applying for a green card. So, if you have thoughts on this, the USCIS is accepting comments through July 6th of this year, so through July 6, 2026. And again, that is what USCIS is looking to change on the AR11. So again, if you have comments, let them know. For my employers out there who are either getting ready to hire foreign nationals, thinking about hiring foreign nationals, or already have foreign nationals on staff, a reminder: Department of Labor is looking to revamp how they calculate prevailing wages. So they are looking to go from 4 levels to 3, and that will raise the average prevailing wage. So we don't have those exact numbers yet. We know that in July we always get a new set of prevailing wage numbers. Not sure if they'll have sort of the whole revamp by July of this year, but even if they don't, my recommendation is to pull all of your current prevailing wages for all of your foreign nationals on staff. For some of you, that may only be one person. For some of you, it may be like 60. For some of you, it may be, 1,000. Pull that information, look at what the current wage levels are, and see if you all can sort of stomach an increase of 2 levels. I'm not saying you have to raise their wages now. I'm not saying you have to do anything, concrete in terms of what you are currently paying your folks, but do an analysis and start that now. Look and see whether or not, if you had to raise the wage level for your employees 1 or 2 wage levels. And I say that just to be on the safe side. This is just an exercise. But see what those calculations do for your business internally. Now is the time to figure out, depending on the size of your company, who needs to be at the table and part of that conversation. Because, we're probably not going to get a ton of time, lead up time before the changes take place. So this is one way where you can really start planning ahead, even though we don't have any concrete information on that yet. I said this to a couple of my friends in the global mobility space. I think it was earlier last week, and they were not pleased. But they admitted it was a good suggestion. But take a look at your wage levels and start really thinking about how your organization is going to look at and what you're going to do when Department of Labor raises those prevailing wages. For some folks, I think that will be a fairly easy conversation. For other people, I think it will be a little bit of a longer conversation. So that's just my 2 cents on that. And the last thing I want to talk about this morning is another reminder that USCIS is looking to end duration of status for those folks in F, J, and I. So keep that in mind. If that moves forward, if they publish that rule, we won't have a ton of time, maybe 30 to 60 days before it becomes effective. And what that will mean is that those folks in F, J, and I status would be given a concrete date on their I-94 card, so a concrete date by which they must leave the United States. Currently, because what they do in the United States has some flexibility in terms of being in school and, needing extra credits, changing your major, that sort of thing, it's a little bit more of a fluid situation for Fs and Js. And for I, members of the news media, the news media, that's, there's always something happening. So their ability to come in and out quickly in order to cover news stories has always been valued. But if if F, J's, and I's have to leave within a certain period of time, that will be a significant shift for those 3 categories. So I'm keeping an eye on that for you. But just if you routinely come into contact with F, J's, and I's, you may want to start again having these conversations within your organization. What will it mean if somebody has a date certain by which they need to leave the US if they are in F, J, or I status? So that is all I have for you this Monday morning. I hope this has been helpful. Have a wonderful rest of your Monday. And if you need any help with any of these issues that I've talked about this morning, feel free to reach out to my office. We're happy to help. And have a great rest of your week.